Here. Hey everybody, this is Mark Smith, the host of Digital Roughnecks, and I'm here with Brian Cromer and Mary Beth Clifford from Step2Compliance. Welcome, you guys.
Good to be
Thank you.
here.
Hey Brian, so tell me about Step2Compliance, what you guys do, and especially as it comes to, because we're going to be talking in this episode about this new Supreme Court ruling against the EPA and what it means for oil and gas companies. So, well, I'll just tell why I brought you on, because these guys are regulatory experts. I mean, they track, well, you'll have to say how many you track. It's 1,300 or thereabouts regulations, and they have a methodology for doing it. But I brought them on because they really know their stuff. So anyway, take it away, Brian.
Yeah, thank you. Thank you. Well, Step to Compliance, I like to say we're a compliance technology firm. We use people and IP that we've developed. So we think of it as an octopus with 130 tentacles. I used to use the word legs, but I was corrected by a biologist that octopus don't have legs. So think about it, an octopus with 130 legs, and then it's got about 1,300 suction cups on it. And so we're physically holding digital reference to the Code of Federal Regulations, to all the state administrative codes, to where agencies publish things in digital form, even if the paper is still the original and the authorized rule format, there's still a digital copy of it, right? So we track these rules, and we founded the company in 2010, and our background is with internal combustion engines. That's our expertise. But better to be lucky than smart, I guess I'd say, because we were able to take a source, that's what an engine is, and pull it through all the federal rules and then pull it through each individual state. And I don't think people had done that before, but we were able to see some things, and we had to consume pretty much everything in air emissions to be able to find out what was related to a source. And because the biggest use of an internal combustion engine is on a compressor, we've been pulled into all these things around methane because the gas itself has become a pollutant since around 2012 for VOCs and 2016 for methane. So that's kind of our expertise. We have these workflows that then help people achieve what's required. You know, it's all, our focus is air emissions, but we do things related to LDAR, leak detection and repair. We do things related to emissions testing, and we help third-party services as well as operators. And Mary Beth has been with us almost since the beginning and has run this octopus with 130 tentacles and almost 1,300 suction cups, and has really put her as probably one of the foremost experts on leak detection and repair and some of the methane rules. So that's kind of it in a nutshell.
So Mary Beth, so when these new things come out like Quad B and C or Subpart W, whatever, you are tasked with actually reading this stuff.
Yes, I am. I get to consume it from end to end.
And make sense of it for everybody else. So, okay, so let's talk about what the Supreme Court ruled on and how that might impact oil and gas companies in terms of, you know, specific things like Quad A, B, C, Subpart W, whatever.
So we had a Supreme Court ruling last Thursday related to the power generation industry, specifically to the Clean Power Plan that had come out under the prior administration or before, let's say, under Obama. And so basically the Supreme Court, I think, ruled effectively that it was overreach from the EPA to set such aggressive greenhouse gas limitations on this sector. Now, it doesn't impact oil and gas directly, but I think it has a direct tie-in to pending oil and gas rules related to methane, like Quad B, Quad C. I think it may impact how those rules are written or the limitation of what the EPA may be able to do. But in general, this rule was targeting power generation and the overreach of the EPA in that category.
So prior to us, you know, hitting record, we were talking about stuff that's statutory, meaning that was voted on by Congress, and then stuff that was legislated and not legislated, but put in through the judicial system. So, for example, Subpart W, which is where all the reporting and stuff requirements, that was literally voted on through Congress, right? So but you're saying to me that Quad A was actually created out of existence through the
Well,
judicial system.
you're gonna bait me here.
Okay.
I was pointing out that we had two Supreme Court case decisions before this one that happened last Thursday. The state of California from 2001 was suing the EPA for the right to put greenhouse gas limitations on automobiles in their state. And then in 2009, the state of Massachusetts also sued the EPA because they were concerned about climate change. They're a coastal region. If there's all of this climate change happening, they're going to flood. You need to do something about it. So both of these court cases were fundamental in establishing the EPA's jurisdiction over greenhouse gases. First of all, their charter is human health. So that's really what the EPA's main job is to protect human health. And then secondly, they need some background in measuring that. So when Obama came into office, he brokered the deal with the state of California, and he had this 2009 Supreme Court case where the state of Massachusetts won, and here we have climate change being hazardous to human health. So he allowed California to put mandates on greenhouse gases for automobiles and adopted those standards at a federal level, which went in force in 2016, which coincides with when Quad A passed, which restricts methane. So we have constraints on greenhouse gases that, rather than coming from Congress into the Code of Federal Regulations, came from the courts into the EPA and then into the Code of Federal Regulations. So, I mean, the process is through Congress and then published in the Code of Federal Regulations, and then that agency that has jurisdiction can act, not from the courts to the agency to then change the code. So that's what we were talking about, but that could be controversial for some people here. I mean, we're definitely good stewards of everything we do. I'm just pointing out how the process is established. And Subpart W came through Congress into the Code of Federal Regulations and then to the EPA. So prior to Quad A, there was no requirements at a federal level to reduce greenhouse gases, only to report them through Subpart W, which Mary Beth will probably speak to here in a minute, because there's significant revisions to Subpart W, which have also been proposed and will absolutely go final. So,
well, speaking of that, what are those changes, Mary Beth?
Well, they're huge. So just to give a little bit of a perspective on that, the proposed preamble and amendments were over 650 pages long that I read through. And then I did a comparison of the proposed changes and the existing Subpart W specifically, because I just wanted to see for oil and gas. And that grew from 120 pages to over 180 pages in length. But I think the main thing that I've really seen through those proposed amendments are some significant changes in the emissions factors and how companies are going to be calculating their overall greenhouse gas emissions. It's really going to probably impact the E&Ps and the midstream segments the most, just because they're introducing an entirely brand new set of emission factors for those who are using OGI or laser technology to do their inspections. Whereas before, you would run the method 21 calculations to establish your leaker rates and determine that. They've now separated those out. And so you either will calculate using method 21 if that was your methodology for inspection, or you will use these new emission factors for OGI or laser. And those new factors run 3 to 10 times higher than the method 21 factors do. So it's going to really accentuate some really huge increases in what those actual emissions are.
Well, estimated.
Estimated.
Yes, the emission factors versus.
Unlike your technology, which is real time, right? We do believe there's a trend towards continuous monitoring, that is the future. I mean, if I look at Clean Connect and the things you guys are doing to innovate, mean, it puts your customer in a potential situation where their greenhouse gases or their methane intensity is actually lower than they're being forced to report. So it's quite possible in many instances that these changes in subpart W will overstate what the actual greenhouse gas emissions are.
Right. And so, I mean, I think, well, we'll talk about what we think the EPA needs to do and SEC and stuff like that afterwards, but let's digest this. Okay. So since subpart W came through Congress, then, and not through the courts, then that part is seemingly going to move through. That's not in any controversy. But since Quad O, B, and C, now A, you thought maybe did come through the courts, but now you got B and C coming through. How do you think this could impact B and C, sort of future things that are being considered?
Well, I mean, my opinion, and then Mary Beth, I'd like you to comment, is that it will probably change some specific language that we saw in Quad OC, which in addition to the 95% reduction in methane emissions that they're proposing they would like, they also said in Quad OC that they would like to set specific greenhouse gas emissions limitations by equipment, like the tank battery, like an engine, a boiler, I mean, they would do this through the SIP, the state implementation plan, kind of similar to how they respond to air quality. But I think based on the Supreme Court ruling that, hey, the EPA's overstepped their boundaries to set greenhouse gas limits for power generation, then why wouldn't we question if they have the authority to set these specific greenhouse gas emissions limits for our equipment? So I don't think it will change the fact that Quad OB and Quad OC are highly likely to pass, but they're also a preamble, and we don't know what their exact language is until they finish writing it, you know.
And so far, and Mary Beth, they haven't put a specific, they say 95% reduction, but they didn't say from what. Is that correct?
Well, it's going to be based on emission factors and throughput and the efficiency of the control technology that's applied, specifically with the Quad OC, because Quad OC is only targeting methane, not anything else. Unlike Quad OA and Quad OB that are VOCs and methane, Quad OC is only methane. But they're really looking to leverage subpart W actually, and the emission factors in subpart W to establish some baselines and then look to achieve certain reductions or put threshold limits on, if you've crossed this threshold of methane, you are subject to this. But again, it's tricky because it's not actually spelled out. But I do think, even though we've got this potential crack in the door that with the ruling last week that would call into question EPA's ability to legislate in this direction and to limit methane and greenhouse gases, the subpart W references Quad OB and Quad OC 32 times, and Quad OB and Quad OC reference subpart W. So like the language between all of these proposed rules and preambles is intertwined. And because of that, I think it's gonna come through. I don't know if it'll change all that much, but yeah.
But really they both address greenhouse gases, which is their interrelation. You know, although I would argue that greenhouse gases need to be addressed in subpart W, you know, not in an SPS, not in a new source performance standard, you know, just based on how the EPA gained their jurisdiction authority to monitor greenhouse gases. So
all they would need to do, I mean, so the Supreme Court says, hey, they can do this as long as Congress gives them the authority to do it.
Well, either way, I mean, you've witnessed everything happening with ESG, environmental, social, and governance, things happening through the financial markets. I mean, the federal role is to set a minimum standards that states must adopt. That's the EPA's charter. That doesn't change the sovereign capability of the state.
Right.
Colorado, California, as an example. You know, it's like I said, we'll have Baskin Robbins, 52 different flavors. if the federal government is not doing their jobs, the states are there to, be enforced. It may be something where you have sanctuary states, but I think, we are in a definitive movement, regardless of what rule changes, that continuous monitoring is our future. That absolutely across the board with different technologies and with existing technologies is what is required to just respond to the collective nature of all air emissions rules at a federal and state level. Because we have states that are far more severe, and we have financial commitments that are far more stringent than what the government is proposing in some of these rules. So I think it's inevitable, the direction. The only question is, what's the slope of the curve, right? How fast is it going to happen?
And since you've been tracking this across different administrations and political type thing, have there been any regulations that have gone away?
No, and I think Quad O is a perfect example of one that didn't go away, right? From Obama to Trump, we're going to take out Quad O. And sure enough, by the end of his presidency, he was able to take out Quad O, or at least methane from Quad O. But immediately after Biden got elected, there was, within this window of a Congressional Review Act, which is the first time I've seen it applied, that Trump's changes were pulled back out. So, I mean, Quad O and Quad O-A, and now it's proposed Quad O-B and Quad O-C, has been probably the most dynamic and volatile rule we've tracked for the last 12 years. I mean, on again, off again, amendments to it, and it just has far-reaching consequences. But the poster child for Quad O is Colorado Reg 7, right? I mean, if it wasn't for Colorado Reg 7, there probably wouldn't be, Quad O in its current form. So
I would say from when I started 10 years ago, the number of rules that I track and monitor has doubled. It's not, they don't go away. There's only new ones added.
Right. So with that in mind, it doesn't, I mean, it's going to move forward, but but all this is really going to do is then help us to predict the kind of, and there's already changes to the Clean Air Act that I'm already tracking coming through. For example, one's proposed to remove the accelerated depreciation, intangible drilling costs, and put those in for everything but oil and gas. So there's going to be changes that'll be put forward in there. But to essentially, one way that the legislature would kind of keep things going on the same track is if they just moved, is it possible to just move the Quad O-BC underneath the same language as subpart W? In other words, just kind of put the whole thing in a legislative umbrella and take out all the court part of it.
Well, I don't know that that's going to happen. I mean, greenhouse gases got inserted into the new source performance standards in 2016. We're a good 6 years into that, and nobody has fought the way that the EPA has gained their jurisdictional authority for greenhouse gases. Until Quad O-A, we only had to report greenhouse gases. There was no limitations at a federal level. But I would say this, that these rules we're tracking, this is our commitment to the industry, and there will be a link. I mean, we've written a summary, Mary Beth's written a summary on the proposed Quad O, B, and C. There's a summary on subpart W. We haven't written anything specific about the Supreme Court ruling, because that's not a rule, it's a decision, and it may impact rules. So as these rules show up, that will be included. But this rule tracking service is free, it's zero marketing, and it's our contribution to the industry. So that octopus with the 130 tentacles and 1,300 suction cups is at your disposal. And we definitely are industry advocates and believe in responsibly produced energy here in the US. So, hope to share that tracking service with you and let you know it's available.
Right. So Brian, yeah, I'm going to put links to all that in the show notes for Digital Roughnecks, but if someone wants to get a hold of you and Step2Compliance and other stuff that you do, how would they do that?
Well, 866-842-0660 is the phone number. Our website is step2compliance.com. You know, we're pretty easy to reach. We post a lot on LinkedIn with these rule changes as well, but we're probably a pretty good kept secret in the industry also because we've been head down and knee deep in it for quite some time. And, you know, kind of not as good as marketing as you are, Mark. You know, we
Well,
probably
we're going to
should
change
run
all that with this episode, okay? So anyway, thank you guys for coming on and helping to, you definitely helped me, and I track this stuff more than most, but it helped me to kind of understand, you know, the implications of this and how it might impact, you know, our listeners and stuff. So thank you very much for coming on. Appreciate it.
Well, thank you for the opportunity.
Thank
Yep.
you. Pleasure.